In this video, I wanted to review Demian v. Frank Associates, which is a business entities law case, one of the first cases that I read in the class in my first semester of law school. Okay, what are the facts? Demian, the plaintiff, was an importer of men's leather goods for sale in the U.S., and he now appeals the judgment which was rendered in favor of the defendant. Frank, the defendant, was a service organization with business contacts in Asia. For a commission, Frank would locate manufacturers to make goods in Asia and import them into the U.S. To help with the process, Frank entered into an arrangement with Sun, who is in Korea, where Sun would get 50% of Frank's fees. Sun, in turn, would locate Korean manufacturers and follow Frank's orders. After approving samples of leather goods or jackets to be made by Koreana, which was located by Frank and Sun, Demian placed 2 orders for the purchase of 2 styles. Demian then sent letters of credit, also known as letters of guarantee, to be honored upon certification by Sun that it had inspected the shipment of the leather jackets made by Koreana and found them to meet specifications. However, Sun did not properly perform its inspection duties, but nonetheless issued the certificate anyways, which released the purchase price to Koreana. Demian then sued Frank for breach of contract. Demian claims that Frank agreed to do 4 things. 1, assist in designing the leather jackets. 2, arrange for the manufacturer. 3, inspection of the jackets to ensure they comply to the standards. And 4, perform all services necessary to accomplish the importation of the jackets into the U.S. Frank, however, denies the allegations and filed a counterclaim for his 5% commission fee. Demian's owner testified that Frank advised that full responsibility would be assumed by him or his man in Korea, aka Sun. Frank's defense was that he only acted as a broker to bring the principals together, similar to a real estate agent. However, in his deposition, Frank testified that he entered into a relationship with Sun, whereby Sun would perform numerous services for him, including locating factories, manufacturing the garments, and inspections. The trial judge found that Frank's services were totally useless and concluded that Sun was an improper person to be appointed as a sub-agent, and as such, there was no vicarious liability. The trial court then entered a judgment dismissing Demian's complaint and found that Frank's services were useless and dismissed the counterclaim for Frank's fees. So what is the legal issue? So for our class, this was a scope of agency question. It was not a contract question, but again, a scope of agency. So whether Sun was employed as Frank's sub-agent to perform his duties as Demian's agent, or was he hired as an independent agent, a co-agent of Demian, for which Sun would assume responsibility. And what's the rule of law to extract? An agent is liable to the principal for the sub-agent's conduct regarding the principal's affairs entrusted to the sub-agent, as the agent is for his own. Put in other words, if Sun was Frank's sub-agent, Frank would be liable to Demian for the sub-agent's conduct. The holding the case was remanded to the district court for further findings of fact. The court dismissed Frank's counterclaim and also dismissed Frank's request for damages. The judgment dismissing Demian's complaint was vacated and remanded to the district court. So it was the court's reasoning. There was clearly no joint venture between the parties since no proof of shared profits. Under agency law, Frank is liable to Demian for Sun's improper inspection if Sun was Frank's subagent. But if Sun was not a subagent, but a co-agent of Demian, then Frank would not be liable. Demian claims that Frank breached an express agreement to inspect the jackets in accordance with the letter of credit. Under this agreement, Frank would be obligated to either A, personally inspect the manufactured jackets, or B, to see that they were properly inspected by Sun, which was obviously not done. If Frank failed to perform these promises, he would be liable under contract law to Demian, regardless of any joint venture or sub-agency theory of liability. The district court, however, did not consider if Frank expressly entered into an agreement with Demian to inspect the goods properly. But the record contains sufficient evidence by Demian that Frank agreed to ensure that Sun, Frank's man in Korea, follow Frank's instructions and ensure proper inspection of the certification, only if the jackets met the specifications. Nor did the district judge discredit Dryban, which is Demian's owner, as a witness, but they did discredit Frank, finding that Frank's services were worthless and in violation of his contractual duties. So again, this case got remanded back to the lower court for further findings of fact to determine whether Frank was a subagent or a co-agent, and whether he had a duty to inspect the leather goods. So more or less the court said, Frank did not have a duty just to find the principal, but he also had a duty to, or believed he had a duty to inspect the goods as well. So they remanded the case back to the district court to see if that were the case. Okay, that was it. If you found it helpful, please hit the like button and subscribe so I can continue to make further reviews. Thank you.